Let go. The Appellate Division, First Department, is now in session. Welcome, ladies and gentlemen, to our virtual admission ceremonies. Ms. Guerrero, please proceed.
Good morning, and may it please the court. I, Veronica Guerrero, counsel to this court's Committee on Character and Fitness, am honored this morning to present to the court 22 applicants for admission to the bar. Further, I am pleased to report that the committee has examined the records of each applicant appearing here today. Accordingly, and on behalf of the committee, I certify that each applicant appearing here this morning does possess the requisite character and fitness to merit admission to the bar of the state of New York, and therefore I do hereby move for their admission.
Before I rule on your motion, I want to take this opportunity to thank the members of the Committee on Character and Fitness for the excellent job they have done to assure that the candidates are all well qualified for admission. The committee's work is important and greatly appreciated by all the justices of this court, and please relate this message to the committee members. Now we turn to the motion before the court. Justice Cardozo famously said that justice delayed is justice denied. Well, there will be no delay of justice today because my colleagues have authorized me to grant the motion. The oath will now be administered by Susana Rojas, the clerk of the court.
Thank you.
Good morning, Justice Kern. Good morning, candidates. I will administer the oath of office in the form of a question. I will ask you to raise your right hand. At the end of the oath, I will ask you to unmute your mics and respond by saying, "I do." Please raise your right hand. I ask everyone, please, to raise your right hand. Thank you. Do you solemnly swear or affirm to support the Constitution of the United States and the Constitution of the State of New York, and faithfully discharge the duties of the office of attorney and counselor at law to the best of your ability? Please unmute your mics and respond by saying, "I do."
I do.
I do.
I do.
Congratulations, attorneys. Please mute your microphones.
Thank the members of the committee. Congratulations, you are now officially lawyers. I now invite the justices to unmute their microphones and give a round of applause for our new attorneys. It is customary for one of the justices to give some welcoming words for the newly admitted attorneys. Today, that honor falls to Justice Moulton.
Thank you, Justice Kern. To all the new lawyers in this virtual room, congratulations. 33 years ago, I was admitted in the First Department. I don't remember the justices who were present that day. I do not remember much about the remarks of the justice who addressed us newly minted lawyers. I do remember asking myself, when is that guy going to stop talking? So I will be brief. You are joining a vital profession, one that is a crucial component of government, of the economy, of all aspects of a well-ordered society. It needs good people to run properly, and you are literally our newest recruits. Our legal system, along with similarly independent legal systems in a handful of other countries, is the envy of the world. A majority of nations do not have the rule of law as you and I understand it. They do not have fair, fully functioning legal systems. By contrast, in New York City in particular, our federal and state courts are a destination for commercial entities from around the world who, if they must engage in litigation, wish to do so in a form free of political or commercial biases and that renders decisions in a reasonable amount of time. Indeed, corporations around the world often write into their contracts forum selection clauses that designate the commercial division of the Supreme Court in Manhattan as the court where any litigation arising from the contract will go forward. The importance to business of a fair and impartial court system cannot be overstated. Without it, businesses are reluctant to commit capital and take risks. Our legal system has also been a means for moving our nation forward on civil rights. For those of you, probably the majority, who are fresh out of law school, cases such as Brown versus Board of Education, Gideon versus Wainwright, Estelle versus Ruiz, Frontiero v. Richardson are fresh in your minds. Perhaps you read biographies of lawyers who change aspects of our legal system for the better, such as Pauli Murray, Thurgood Marshall, and Ruth Bader Ginsburg. Perhaps you take inspiration from them. However, you should never, ever consider our legal system to be perfect and immutable. Our legal system is a work in progress, and you all have a role in changing it for the better. A moment ago, I spoke about how well we do in commercial litigation and how we attract the world to our courts. However, other aspects of our legal system are sorely in need of attention and resources. Poor and working class people often have no access to a lawyer in civil litigation. In criminal courts, our assigned defense counsel often do an heroic job, but they're overworked and under-resourced. Having no lawyer or an overwhelmed lawyer is a disability in seeking a fair outcome. Economic status should not determine outcomes in our courts, but too often it does. Obviously, there have been times in our nation's history where lawyers have played a malign role in perverting our legal system. Joseph McCarthy was not a lawyer, but he was assisted by very able lawyers in his red baiting. Lawyers working for large corporations have, on occasion, gotten away with criminality in obscuring the health effects of dangerous products. Prosecutors have, on occasion, acted to enforce white supremacy in our criminal justice system. The imperfection of our legal system is reflected even in the First Department's beautiful courthouse. If we were sitting in our courtroom right now, you might look up into the stained glass dome in its center. You would notice the names of a number of legal luminaries, including John Marshall. However, that cupola also contains the name of Roger Taney, the Chief Justice of the U.S. Supreme Court who wrote Dred Scott versus Sanford, in which the U.S. Supreme Court held that the privileges and immunities of the U.S. Constitution did not apply to African Americans, whether they were enslaved or free. The presence of Taney's name in our beautiful courthouse is a reminder to me of our imperfect legal system and how all of us as lawyers must work to improve it. How can you do that? Well, you should do pro bono work for underserved communities. That's truly a win-win endeavor because it will simultaneously help out someone who needs help in a landlord-tenant dispute or a criminal matter or in a consumer debt case, and it will give you hands-on legal experience and greater responsibility than you might have as a young lawyer. Second, you should join one of the numerous excellent bar associations that exist in New York City. A bar association's very mission is to improve aspects of the profession. In sum, remember that you are a member of a vital profession that can be an immense force for good. Act with integrity, with intelligence, and with heart. Good luck.
The admission ceremony is now concluded and court is adjourned.